Let's talk about the Rocky Ford decision. Before, I said that the Chaplinsky decision was wrong, Orwellian wrong, meaning that on the face of it, not only does it look like it's true, or not only is it not true as it's presented, but the opposite is the truth. And the same goes for the Rocky Ford decision. So the Rocky Ford decision refers to the city of Rocky Ford versus Robert J. Brown, 1956. This was decided by the Colorado Supreme Court on February 20th, 1956, and the verdict was that the judgment and the order of the trial court, the first court, was right and should be and is affirmed. So they had actually sided with Robert J. Brown. So the city of Rocky Ford is going to lose. Robert J. Brown, Roy C. Horton, and A.S. Kitch won. They beat the municipal corporation that is Rocky. The two major points of the Rocky Ford decision is essentially when citizens get a petition and they have the right number of signatures. So they have a petition and it's in proper form, in proper order, it's on the right form, and they have enough signatures, then nobody can stop it from being put on the ballot until after it has been voted upon. So this happened because the city clerk, on the advice of council, violated the provisions of initiative and referendum laws, and even though it's not willfully and intentionally done, she broke the law, or the city clerk had broke the law because they wouldn't put this citizens initiative on the ballot. So what it says here is no discretion rests with administrative officials to pass upon the validity of an act proposed by the people in the exercise of their right to vote. No discretion rests with administrative officials to pass upon the validity of an act proposed by the people. When the people put an initiative forward, then it's up to the people to vote upon it or to reject it. If they express their sanction and approval of the ordinance by their vote, and its enforcement is attempted by one whose rights are affected, then the courts are open to pass upon the question of its validity. So that means that the people's initiative, if people get signatures in the proper right, proper form, in the proper form and the proper signatures, then it must go on the ballot. There's nothing that the city clerk or the county clerk or the mayor or the city manager or the city council, nobody can do anything about it. Not even the council, the city lawyer. The city lawyer tried to say that it was illegal. The city lawyer said that it wasn't legal. These guys, Robert J. Brown, Roy C. Horton, and A.S. Kitch, had put the petition in order, but they were rejected. The city clerk had rejected their petition because the city lawyer had advised them that it was illegal what they were doing because of the previous election. The previous election had actually decided one thing, and then this initiative was to attempt to nullify it and overturn it. So what was that election? I think it's important to find out what that election was. But first, I just want to get to the main points of the Rocky Ford decision. The city of Rocky Ford versus Robert J. Brown, 1956. So the main element of the case is that the initiative powers are absolute and plenary. When the people get enough signatures and they have a proper form and it's presented to the proper clerk, the proper office, then they must put that initiative on the ballot for the people to decide. City officials can stop it, nor can the courts intervene. That's what the Rocky Ford decision says, that the courts cannot intervene in between an initiative. So I think if you take this to, its logical conclusions, then it's absolutely wrong. Because what they're saying is if the people put an illegal ballot measure on the ballot, then nobody can stop it until it's voted upon. And then after it's voted upon, when the people try to enforce it, that's when you can sue. That's when you can bring the courts in, only after the election. So I disagree with that, but that's the main thrust of what the Rocky Ford decision is about. Neither this nor any court may be called upon to construe or pass upon a legislative act until it has been adopted. So the courts can't mess with it, nor can the mayor or the city clerk or the city council or the city lawyer. Nobody can stop the municipal corporation, because that's how they wrote it, the city of Rocky Ford, municipal corporation. Then they wrote Robert Appleman as mayor, George Forbes as city clerk, and C.R. Schuth Kenneth V. Bolton, Arthur G. Johnson, Carl M. Eustick Jr., Daisy Whitaker, and Howard W. Grimsley, constituting the City Council of said city, plaintiffs in error. So for some reason they're called plaintiffs in error, and Robert J. Brown, Roy C. Horton, and A.S. Kitch are defendants in error. So Justice Holland is the one who wrote the majority opinion. So this is all Justice Holland, 1956. So it says, by this writ of error, a review is sought by a judgment favorable to defendants in error in the action in the nature of mandamus commenced by them as a statutory committee representing what the Rocky Ford case, the Rocky Ford decision, Rocky Ford v. Brown, 1956, what it specifically tried to do was this. By this writ of error, a review is sought of a judgment favorable to defendants in error in an action in the nature of mandamus commenced by them as a statutory committee representing petitioners and presenting to the City Council of Rocky Ford a proposed franchise ordinance initiated by the people pursuant to the initiative and referendum laws of Colorado. A defendant in error is a party to whom a writ of error is issued. A writ of error is issued by an appellate court ordering a lower court judge to send the case record for review and examination. The aim of this writ is to get a reversal of the lower court's judgment. So that's what Justice Holland is doing. This is what he wrote this up, and here's findings of 1956 Colorado Supreme Court found out was this. The findings of fact was that the initiative petitions were presented and properly filed on June 20th, 1955 with the city clerk of Rocky Ford. The initiative petitions were in proper form and contained the required number of signatures. Rocky Ford is a city of the second class, is not a home rule city, which is important. The first demand of the petitions was a request to the city council to adopt an ordinance granting to the Citizens Utility Company, a foreign corporation allowed to do business within the state of Colorado, an exclusive 25-year franchise to operate a natural gas distribution system in the city. So the company wanted it was a natural gas company, and they wanted a 25-year lease. The past election was basically eminent domain. It was the other case, the Citizens Utility Company versus the city of Rocky Ford. So it's essentially reversed, but they actually used the corporate name. So there was a previous case 1 year prior to this that had made the election illegal. And the question on the 1954, October 14th, 1954 ballot was two questions. They had two separate ballots, and they could yet vote yes or no to either one of them. So the first question was, shall the city of Rocky Ford be authorized to acquire a municipally owned natural gas distribution system for said city and its inhabitants as provided by ordinance number 377 of said city? Yes or no? Number two, shall Rocky Ford ordinance number 377 adopting a plan for the acquisition of a municipally owned natural gas distribution system be approved? Yes or no? So it sounds like very similar. That was the first demand of the petition of Citizens Utility Company, was to tell the city council to pass the ordinance. And if city council didn't pass the ordinance, then they wanted it to be put on the ballot. So if the ordinance was vetoed by the mayor, or if it was not passed over his veto, or if the city was against it, to submit the proposed ordinance to a vote of the qualified electors of the city at a special election to be held on August 30th, 1955. Those are the two demands of the petitions. So the one petition was city council, pass this ordinance. If city council doesn't, then it was going to go to the people. And number 6, it is shown that the city attorney advised the council that the proposed ordinance would be invalid. Further, it would be inconsistent with and contrary to the vote of the taxpaying electors. An election held on October 14th, 1954 would not be in conformity with the provisions of the Constitution and laws of the state. The city council, following the city lawyer's advice, refused the request of the petitioners and the action in the nature of a mandamus. And that was filed July 21st, 1955. So those are findings of fact. There was a previous election, and that election was ruled invalid. So they overturned an entire election. They're going to try to tell me that they believe that the people's initiative is so sacred, even if they put illegal shit on the ballot, there's nothing anybody can do about it until after the people vote for it. I call bullshit on that. But they're going to tell me that the initiative is so damn sacred, but the election, a people's election, isn't sacred. They can overturn a people's election because the people know not what they do. So they give a wide discretion for the city to either acquire or to create for themselves a natural gas company of just insane, ridiculous. What could the people put on the ballot that would just be, it would shock the conscience? It would just be on its face illegal. I think if it's unconstitutional, it should be illegal. It shouldn't deprive our freedoms. It shouldn't try to ban the First Amendment or its 5 freedoms or the Second Amendment or the Third Amendment. If they had a ballot initiative to allow quartering soldiers, even during peacetime, soldiers could come into your home even during peacetime and live in your home and eat all your food because they're soldiers. So they're that much more important. Of course, they can, live and eat and do as they please. That goes against the Third Amendment of the U.S. Constitution. What about dropping a nuke on Detroit? What about allowing Sally Jesse Raphael to rape everybody in the city? What about concentration camps for the homeless? What about sending the Christians out to Hawaii? On a personal standpoint, I do not agree with the Rocky IV decision. It says that the people's initiative must go forward. Nobody can challenge it. Nobody can say that it can't go forward if it's got the proper paperwork and the proper signatures. Even if it's unconstitutional and illegal and nonsensical and possibly evil. So some evil, unconstitutional, drop a nuke on San Antonio, Texas. If they were to put that on the ballot, they got the signatures and it was in a proper form, we have to put it on the ballot. Nobody can stop. I say bullshit. I think if it's illegal or if it's evil, if it's any of those ones that I just mentioned, it should be nipped in the bud and it should not be allowed to go forward. So I do not believe that the people's initiative is so absolute that it could deprive a certain section of our people of their lives or their freedoms or their rights, or it can't be unconstitutional. Lawyers today in Colorado they say because of the Rocky IV decision, we cannot sue a stupid, unconstitutional, illegal, or evil ballot initiative put forward by the people until after the election because of the Rocky IV decision. Well, the Rocky IV decision was made in 1956. The cases that they referenced was 1932 City and County of Denver v. Whittam and a 1912 case Spear v. People. So this is a 1956 case. The reference in 1912, 1932. I think we need to update these things. And it's also, compared to Pueblo, Pueblo is a home rule city. So the city of Rocky Ford wasn't a home rule city, and they were using state laws back in 1956, which aren't in effect today. So what the Rocky Ford decision said, the city clerk, because they stopped the people's initiative, should go to jail. That's what the Rocky Ford decision says. Position of plaintiffs in error before this court and before the district court is a request for an advisory opinion upon proposed legislation and in connection with which it had a plain statutory duty to perform. The ordinance was proposed pursuant to the initiative and referendum laws of the state, which, when invoked by the people as here, the council or representative body, is supplanted by the people who are proposing to legislate for themselves. Whenever the provisions of the initiative and referendum laws are applied as here to local and municipal affairs, the city or town clerk shall perform the duties specified, and upon failure to perform these mandatory duties, or shall refuse to submit any petition in the form presented for submission at any election, is subjected to the penal provisions of the statute providing for a fine and imprisonment. So if you try to fuck with the people's initiative, even if it means, we're going to take all the homeless and put them in the gas chambers, the very heart of the Rocky IV decision, they say, is plain that here the city clerk, on advice of council, violated the provisions of the initiative and referendum laws, no doubt due to the unfamiliarity, what a dumb word, but with the provisions thereof, and not willfully and intentionally. So they're saying that because she had bad counsel, she had bad advice by the city lawyer, that she didn't intentionally do it nor willfully do it, but it was broken. The law was broken nonetheless. And they go on. No discretion rests with administrative officials to pass upon the validity of an act proposed by the people. The people, in the exercise of their right to vote upon such proposal, wisely adopt or reject it. If they express their sanction and approval of the ordinance by their vote, and its enforcement is attempted by one whose rights are affected, then the courts are open to be considered. They're saying that the separation of government powers must be held inviolate. Therefore, the trial court or this court may not intrude upon the legislative powers through an advisory opinion until afterwards, until the people who's being affected can do it. So, again, it's essentially saying the people's initiative in Colorado is so sacred. Once it's in proper form, proper paperwork, and proper amount of signatures, it must go on regardless of what anybody says or does or anybody tries to say or do. I disagree. I do like the principle of initiative, but to say that it is absolute, it's not absolute. It can't go against the Constitution. What if they said, let's shred the Constitution and install Sharia law? So can we install Sharia law by ballot initiative if the people put Sharia law up as a question and the people vote for it? Are we stuck with it now? So they said that before them, the duty of the clerk and the city council is clear. It is not within their discretion to question the acts of their principal, the people. So administrators can't question the acts of their principal, the people. So when the people put an initiative, and it's the people, right? So some people put the initiative up. Some people signed that petition, but not all people. There's a percentage. So they got, what, 5% of the people on the petition? So it's not like all the people. This is anyways, the people's initiative. Once a group of people puts the initiative on the ballot, then nobody's allowed to say shit. So if anybody tries to block it, then they're saying that they could be held to account, and they might even go to jail, pay a fine, and go to jail because it's illegal. It's clear from the provisions of the Initiative and Referendum Act and the penalties provided thereby that the legislator has been careful and diligent to safeguard the primary right of the people to propose and enact their own legislation. Neither this nor any other court may be called upon to construe or pass upon a legislative act until it has been adopted. So they're saying that the People's Initiative is a legislative act, and you cannot rule on a legislative act until it has been adopted, until after the people had voted for it. So when it's proposed, you can't question its legality, is what the Rocky Ford decision is saying. I disagree. I propose Sharia law. You're not going to you're going to allow that to go on the ballot just because I got enough signatures and I did it in the proper form. That's bullshit. That's insane. So I think it's preposterous notion what Rocky Ford is saying. There's also this other case that makes it seem like they're biased in favor of a foreign corporation over a town municipalizing their own natural gas works. Exception to this rule, according to Rocky Ford, the only exception to this rule is the constitutional provision authorizing the legislature to propound interrogatories to the Supreme Court upon important questions upon solemn occasions. Constitutional Article 6, Section 3. That reads original jurisdiction opinions. The Supreme Court shall have power to issue writs of habeas corpus, mandamus, quo warranto, certiorari, injunction, and other such original and remedial writs as may be provided by rule of court with authority to hear and determine the same, and each judge of the Supreme Court shall have like power and authority as to writs of habeas corpus. The Supreme Court shall give its opinion upon important questions upon solemn occasions when required by the governor, the Senate, or the House of Representatives, and all such opinions shall be published in connection. An injunction is a writ, also known as an order, issued by a court ordering someone to do something or prohibiting some act after a court hearing. So a court order. An injunction is a court order, a writ, telling them to do something or prohibiting some act after a court hearing. One note I want to make, the Rocky Ford case, just like Dan Kagavsek, they moved to dismiss the petition for failure to state a claim upon which relief could be granted. That's the same shit he threw at me, but the Rocky Ford court actually bypassed that. They said, we're not listening to this shit. We're actually going to hear the case. There's also for preventing citizens' utilities, it's ballot initiative. It says the Rocky Ford city clerk should have gone to jail. It also declared that no administrative officials, if the petition is in the right order, proper forms with the right amount of last sentence of the paragraph that I referenced. In the first instance, the proposed ordinance is clothed with the presumption of validity, and its constitutionality would not be considered by the courts by means of a hypothetical question, but only after enactment. So once the people's initiative get on the ballot, then only the people can deny it, or the courts can deny it afterwards, after that legislation has been approved. That's the reason why the Rocky Ford decision, that's the reason why Justice Holland decided with the foreign corporation, the foreign capitalists, Robert J. Brown, Roy C. Horton, and A.S. Kish of Citizens Utilities Company. So they sided with the corporation against the city to municipalize their natural gas industry. So municipalizing natural gas industry is a controversial measure. Is it possible that Justice Holland was on the side of private interest and not for municipalization?